Hello and good morning, and welcome to Gough Square Live. My name is Jonathan Goulding, and I'm joined by Laura Phillips. We're both barristers at Gough Square Chambers, practicing in consumer and regulatory law. Today we're going to be talking about some recent food law cases. The four cases we have selected to discuss today are either appeals or claims for judicial review. One was heard by the First Tier Tribunal, and the other three in the High Court. Whilst they are all about food, each is entirely different from the others. It is a diverse collection of the very recent food law cases, ranging from the definition of raw honey to the permitted use of the term milk, and from contaminated cat food to whether or not monk fruit is a novel food. As in previous Gough Square Lives, we won't be answering any questions on air, and we will aim to complete the whole talk in under 20 minutes. Do, however, still feel free to email us later if you have any questions. The Odyssey case. The case references to the cases we are going to discuss are on the slides. Odyssey imported minimally processed and unpasteurised honey from Greece, which it labelled raw honey. The authority issued an improvement notice pursuant to Section 10 of the Food Safety Act 2010, requiring Odyssey to cease using the term raw honey. The authority's approach was based on national guidance on raw honey, issued by the Association of Chief Trading Standards Officers, ACTSO. The authority stated that the term raw honey was misleading to consumers, as it suggested that the food possessed special characteristics, which in fact all similar foods possessed, within the meaning of Article 7 of the Food Information to Consumers Regulation, EU 1169 of 2011. Since the Honey England Regulations 2015 provided strict compositional criteria for honey products, which included measures designed to restrict processing and heating of honey, the authority argued that all compliant honey sold in England could be described as raw. As such, to describe Odyssey's honey as raw suggested that there was something special about the product when in fact there was not. Odyssey appealed the improvement notice to the First Tier Tribunal, FTT. It provided evidence of its manufacturing process, which it submitted was distinctive in nature by not employing pasteurisation. It also commissioned scientific tests of its honey, which were then compared to the results of other honey products available on the market. The FTT held that the tests supported Odyssey's case and that there were observable differences in its product which resulted from its manufacturing process. The FTT allowed the appeal and rejected the authority's argument. Tribunal Judge Neville described the ACTSO guidance as a very unhelpful document, which provided a shaky basis for the authority's case. He concluded that Odyssey's limited-run single-source honey would satisfy just about everyone as being raw honey. The word raw accurately conveys the lack of processing, including but not limited to heating, undergone by Odyssey's honey when compared with many others. He also made the following comments about honey regulation more generally. At paragraph 49 of the judgment, he said, "I find that the scientific and other evidence discloses a realistic likelihood that large honey producers may be routinely subjecting honey to sophisticated heating and crash cooling methods in such a way that its HMF and diastase levels remain just within the regulatory requirements. It is plainly in their interests to do so. I can properly take notice that malleability, homogeneity and longevity are necessary and desirable qualities in food sold to supermarkets, especially for their own brand products. It would not be surprising if over time producers have improved their technology, sources of honey and their blend recipes." And at paragraph 50, he said, "The evidence of Mr. Payne and the ACTSO guidance gave me a strong impression of an institutional reluctance to engage with developments in manufacturing technology and practices, and to address whether they may put honey in breach of the separate requirement that enzymes should not be significantly deactivated. At the very least, the ACTSO guidance and its defence reveals a lack of understanding about pasteurisation, flash heating conducted by industry and its effect on products. It should be noted that the tribunal did not actually hear any evidence from other honey manufacturers, so it should probably be considered to turn on its own facts. What is clear is that the law and guidance is currently in an unsatisfactory state, and clarification is required urgently.
I'm going to talk about the Oatly case. This wasn't a food case at all, in fact, because it concerned trademarks, but it is useful for those who deal with food businesses because it concerns how food products may be marketed. This was an appeal to the High Court against the decision of the Intellectual Property Office that Oatly's trademark, post-milk generation, ought to be declared invalid because it contained the word milk, when Oatly's products were not milk products. Oatly, as some of you may know, manufactures various oat-based alternatives to dairy products. It applied to register a trademark for post-milk generation, which is used on the packaging of some of its products. Dairy UK Limited, which is a trade association for the dairy industry, as you might guess from its name, objected on the grounds that the mark offended against Section 3.4 of the Trademarks Act 1994. Sections 3.3b and 3.4 of the Trademarks Act 1994 provide that a trademark shall not be registered if it is of such a nature as to deceive the public, for instance, as to the nature, quality, or geographical origin of the goods or service, or to the extent that its use is prohibited in the UK by any enactment or rule of law. Dairy UK Limited argued that the use of milk in the trademark was prohibited by reason of Article 78.2 and Part 3 of Annex 7 to EU Regulation No. 1308 of 2013, which prohibited the use of the term milk in the marketing of products unless milk referred to the normal mammary secretion obtained from milkings. Dairy UK Limited said that the designation milk could not be used for products which were not milk within the meaning of Annex 7. In doing so, it relied on a European case with a very long name known as Tofu Town. If anyone wants the reference, it's C422/16, which held that the use of terms such as tofu, butter, plant, cheese, and so on breached Article 78.2 because milk, etc., were designations reserved by European Regulation 1308/2013 exclusively for milk products. The UK IPO, Intellectual Property Office, eventually agreed with Dairy UK Limited and declared Oatly's trademark to be invalid, so Oatly appealed. The High Court took a different approach to the UK IPO and to Dairy UK Limited. It considered that whilst Regulation No. 1308/2013 prohibited the use of the term milk to identify non-milk products, it did not prohibit the use of the term in marketing altogether. In this case, it was clear from the circumstances that the mark referred to the customer, not the product, and Oatly's products were neither being identified nor marketed as milk by the use of the trademark. In fact, the contrary was true. There was no likelihood that any consumer would be misled. This case shows the High Court taking what is really a common sense approach to the application of legislation. Again, this case should be considered to turn on its own facts, but it's an interesting illustration of why great care must be taken in relation to the use of terminology specific to particular foodstuffs, so milk, butter, champagne, and so on, in marketing in order to stay on the correct side of the law. The third case we're going to talk about is the Fold Hill Foods case. This was a judicial review concerning the lawfulness and rationality of the FSA's actions and decisions in respect of a recall of cat food products, so pet food, following an increase in PCP cases affecting cats. So PCP, panocytopenia, is a very rare condition in cats which causes death or serious illness, and there was a spike in these cases. This understandably caused concern amongst cat owners and retailers of cat food, and the Royal Veterinary College issued a call for information. Following that, it considered that the common factor between the cases appeared to be the food eaten by the affected cats, and it identified 4 brands of dry food in particular, including brands produced by Fold Hill Foods Limited. The Royal Veterinary College informed the Food Standards Agency, and the Food Standards Agency conducted an investigation and notified Fold Hill Foods that there was epidemiological evidence linking its cat food products to the PCP outbreak. Fold Hill Foods implemented a recall of its cat food brands, which was accompanied by the FSA issuing a product recall information notice and subsequent public updates about the recall. This resulted in significant financial losses to Fold Hill Foods. After the recall, there was an increase in the number of affected cats, but the number of new cases then fell. Fold Hill Foods made a claim for judicial review to the High Court on the grounds that the FSA had acted unlawfully and/or irrationally in, first, allegedly threatening to compel a recall of the claimant's cat food from sale; second, in its advice to Fold Hill Foods, the claimant, before the recall and in issuing the product recall information notice; thirdly, failing to comply with the public information obligation in Regulation 10 of Regulation 178 of 2002, European Food Hygiene Regulations, which says where there are reasonable grounds to suspect that a food or feed may present a risk for human or animal health, then depending on the nature, seriousness and extent of that risk, public authorities shall take appropriate steps to inform the general public of the nature of the risk to health, identifying to the fullest extent possible the food or feed or type of food or feed, the risk that it may present, and the measures which are taken or about to be taken to prevent, reduce or eliminate that risk. And what Fold Hill Foods were arguing was firstly that the public updates by the FSA were not justified by Regulation 10 because there were no reasonable grounds to suspect that Fold Hill Foods foods may present a risk to animal health, and secondly, that the FSA had failed to inform the public fully of the risks to public and animal health because there was a possibility that the outbreak of PCP was not either not caused by the Fold Hill Foods products at all, or was not solely caused by them. I'm going to say very little about the ground relating to the lawfulness of the recall because it's less interesting to us in terms of legal issues because it essentially concerned a dispute of fact, who said what. The parties agreed that in law the FSA had no power to recall Fold Hill Foods to recall its products. The FSA denied making any threats, saying that it would recall the products if Fold Hill Foods didn't agree to do so. The FSA's position was that it had provided advice to Fold Hill Foods and it was entitled to do that, and it hadn't gone any further. On the evidence, the court found that the FSA had encouraged but did not compel the recall, and it did not threaten to impose a recall if Fold Hill Foods didn't do it voluntarily. So that was the ground relating to questions of fact. The other grounds relate more to issues of law, and so I'm going to spend a little more time on them. Looking at the grounds relating to the rationality of the recall advice and rationality in issuing the product recall information notice, Fold Hill Foods essentially made two complaints about the FSA's evidential basis for its actions. First, it said that the level of mycotoxins, so the things that essentially cause PCP in recalled feeds, were below the guideline levels of what was considered safe, and some of the dead cats had only eaten wet food. So, in other words, there was evidence that the outbreak of PCP was not just linked to Fold Hill Foods products. Secondly, it said that the FSA should have done more to assess whether all of the recalled foods were unsafe. And there was an argument that the FSA's testing was unreliable because it should have taken into account evidence about how the mycotoxin was distributed within the food tested. And once Fold Hill Foods said that once the FSA had accepted that there was no definitive or causative link between the recall foods and the outbreak, which the FSA eventually did, it should then have gone on to tell the public that the recalled food was in fact safe. The court started by reminding itself of the approach it needed to take in respect of a claim that a decision maker is acting irrationally. Now, these, as many of you will know, are well established. the case of Mott and the Environment Agency from 2016. And then there's the case of Tameside, which is a House of Lords decision from 1977. I'm going to paraphrase these principles quite a lot, but essentially what we take from those cases is that the rationality of a decision is to be assessed having regard to the context of the decision, including the nature of the decision maker. Second, that rationality and lawfulness are not the same as merits. And in principle, the court should afford the decision maker an enhanced margin of appreciation in cases involving scientific, technical, and predictive assessments. Thirdly, that rationality requires the decision maker to ask him or herself the right question and to take reasonable steps to acquaint himself or herself with the relevant information to enable him or her to answer it correctly. That's the Tameside duty of inquiry. But it's usually for the decision maker to decide what is reasonable in the circumstances. So we can see from that it's a high bar. After a 2-day hearing, the High Court adjourned and in due course handed down a reserved judgment dismissing the claim. So as I've just mentioned, the case confirmed that irrationality is a high bar, particularly where there is scientific and technical evidence involved and the decision maker is the person designated by the state to have responsibility for enforcing the legislation, in this case for protecting animal health pets. The court held that it was appropriate for the FSA to err on the side of caution, taking into account the gravity of the risk to the affected cats, how serious PCP is as a condition, and the purpose of the product recall information notice and updates, which was to provide information to cat owners about the cat food which could safely be given to their cats. So even though the FSA had eventually accepted that there was no causative link between the recalled pet food and the PCP outbreak, applying the approach just described, the FSA had not in the circumstances breached the duty of inquiry set out in the Tameside case and had not acted irrationally on the evidence before it. Now, in one view, this might be considered an injustice for Fold Foods, but the purpose of judicial review proceedings is not for the court to substitute its own views or to carry out its own evidential assessment, but to apply the principles developed in the case law to ensure that decision-making by public bodies is not unlawful, irrational, or unreasonable. And in this case, none of these thresholds were surmounted, with the result that the FSA's decision could not be impeached, even though it might have taken the precautionary principle in food safety to a very high level.
Thank you, Laura. The last case we're going to talk about is the monk fruit case, and you'll see the reference in slide 2. Monk fruit is a small round fruit from the melon family, and it is known for its sweetness. It is cultivated primarily in China and used as an ingredient in various foods, including tea and desserts. The claimant manufactured monk fruit products. It asked the FSA to determine whether monk fruit was a novel food for the purposes of the novel food regulation. If the food was non-novel, it would not require a novel food approval. If novel, it must be approved by the authorities based on safety checks, and this is a complex process. The claimant submitted a dossier of evidence to support his case that monk fruit was not a novel food because it had been used for human consumption to a significant degree within the EU or the UK before the 15th of May 1997. The FSA concluded, purporting to apply EC guidance, that there was insufficient evidence to satisfy that test. The claimant challenged that decision by way of judicial review. The grounds were that A, the FSA had fettered its discretion by requiring invoices and receipts to demonstrate consumption pre-1997, and had been wrong to conclude that personal witness testimonies were incapable of meeting the statutory test unless they were verified by an independent source. B, the FSA was wrong to say it was necessary for monk fruit to be consumed exclusively for food uses. The FSA's case was that this was not what they said, or at least not what they actually meant, and they served 4 witness statements to further explain and clarify the intended meaning of the words in the decision. Mr. Justice Calver took a rather dim view of what he considered to be the FSA's attempts to and I quote him, rewrite the reasoning contained in the decision so as to give a version of the reasoning in the decision which cannot stand with the wording of that document itself, as well as the agency's explanations of their reasoning pre and post decision, unquote. As such, applying the principles summarised in the case of Nash and Chelsea College of Art and Design, a 2001 case, he ruled that the 4 witness statements the FSA produced for the judicial review hearing were inadmissible. In consequence, the FSA's approach to the application of the statutory test was flawed, and the claim for judicial review succeeded. In his judgment, Calver J. examined the FSA's decision making process in detail. He found that the FSA had rigidly applied the EU's guidance on weighting of evidence instead of considering the whole picture. In particular, the FSA, applying the guidance, was wrong to consider that the lack of comprehensive sales information prior to 1997 meant that the company could never demonstrate a significant history of consumption of a food, regardless of the quantity or strength of alternative information based on personal testimonies. He also found that the FSA had incorrectly imposed a requirement that the claimant's evidence needed to be independently verified. This was not a requirement imposed by the novel food regulation. The judge also found that the FSA's approach to the novel food assessment was therefore wrong in law. The decision was quashed, and he ordered the FSA to reconsider the claimant's dossier in light of his judgment. In June 2024, the FSA considered the evidence of a history of consumption of some products containing monk fruit as an ingredient within the EU or UK before 1997. It deemed it was sufficient to demonstrate a significant history of consumption. As a result also of the decision of the High Court, the Food Standards Authority in Ireland has agreed that its decision on similar grounds, deeming monk fruit to be a novel food, should be quashed by agreement following a similar judicial review challenge in that jurisdiction. It subsequently decided that monk fruit concoctions are not novel, and as a result there is now unanimity across the EU and the UK that monk fruit decoctions are not novel foods. Laura.
Thank you, John. So as we've seen, food law continues to produce very interesting and important cases in the higher courts in the UK. These cases that we've discussed today have dealt with food descriptions, food labelling, novel foods and food recall. And they show that the issues that are being litigated are diverse and plentiful. So thank you for listening in. Hopefully we've provided you with an interesting skip through these cases and you found them as interesting and informative as we have. Please feel free to get in touch with us by email with any queries and we'll try our best to provide you with an answer. Thank you again for listening.